All right, continuing on with my theme of real estate and estate planning matters, let's talk about a few instances. So the first is when we have a married couple, but only one of the two is on a deed. What are we going to do for planning purposes? Well, last video, I mentioned the step up in basis. And if we simply add the other spouse onto the deed, instead of the one spouse having a full tax cost basis, we've split the tax cost basis to the two of them. So generally then, when spouses own property together, each is considered to have half as far as a tax cost basis. Now, that may not be a problem for residential real estate that is used by both as their principal residence, and I'll talk about why, but that really could be a problem for property that is not principal residence property. Because for principal residence property, we have an exclusion in regard to capital gains taxes. So as long as you have owned the property and lived in the property as your principal residence for 2 out of the preceding 5 years prior to a sale, you get the capital gains tax exclusion. But other property that's not going to be considered your principal residence, you've split the tax cost basis. Now, when one of the two passes, only half receives that step up in basis and the other doesn't. Now you've created an issue as far as taxes go and looking to have to pay capital gains taxes that didn't otherwise have to be paid if different planning was done. What's the different planning? Well, the spouse that owned the real estate 100% could set up a lifetime trust. Transfer the property to the lifetime trust. The lifetime trust and the property within it will be prepared such that the property receives the full step up in basis upon passing. And then when the property is later sold, because of that full step up in basis, we're avoiding those capital gains taxes that we otherwise might need to have paid if we had simply added the spouse to the deed. And this can also be thought of in regard to sole member LLCs, where one of the two owns all the member interests in an LLC. And instead of just adding the spouse as another member, we can think about transferring the LLC to a lifetime trust. And then again, get that full step up in basis. So something to think about. Now, the next thing I want to think about is actually setting up an LLC. So I handled an estate and we concluded the estate by distributing real estate in a different way. So we had unique real estate. It wasn't a home. It was very special as far as what this person enjoyed out of it during his life. And everybody in the family knew they wanted to continue to enjoy the real estate, but they didn't want various concerns in regard to the real estate. The biggest being they did not want personal liability in regard to the real estate. So what we did is we set up an LLC and we issued member interest to the beneficiaries as opposed to putting an executor's deed on record and all of those beneficiaries being tenant and common owners with each other. We set up this LLC, we issued member interests, we had the LLC managed by a manager, and therefore we had one person making the decisions in regard to the LLC. We worked out some plans as far as having some cash to pay some expenses and so on. And on top of that, we set up an operating agreement tying in what everybody could and could not do and what they needed to do for capital contributions in regard to the LLC. So people couldn't just outright transfer to anybody. They could only transfer to children or grandchildren, and they had to contribute so much per year to pay their fair share of everything and so on. But it was a wonderful way for the family to come together and do something that would be beneficial into the future, enjoy this property without the liability concerns and so on. Now, the person who passed obviously could have done this during life, And it's something to think about, especially with that other kind of property that's not your principal residence property, but something else. But I'm glad that we were able to do that at the estate end of things. So when real estate is part of estate planning, or when a person passes and is part of an estate, so many factors come into play. It's really important for people to continue to think about these things and not just think it's one and done in regard to any kind of estate planning matters. Now, I just continued on with a workout that I did at home. And so I wanted to tell everybody that I think estate planning is much like working out, right? You make the decision to do it, you act, and you feel better after you've done it. So I hope everybody can continue making good decisions with estate planning. It's so important to plan and not just make quick decisions, but think about what you're doing and how will it affect you and those that you love. So this is Ruth George with Ruth P. George Law, LLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship. I hope you make good decisions, and I hope to see you on another video.